So just to introduce myself to those of you that I haven't met before, so I'm Maddie Olhead and I work in the Department of Education's Attendance Policy Unit. I'll be presenting alongside my colleague Faye Thompson today, and we're also joined by Vicky Lavery, who's sharing the slides very helpfully, and Amy White from the Attendance Division too. The webinar today is going to focus on grounds for deletion from roll as set out in the School Attendance Pupil Registration Regulations 2024. As we know, many of you are already aware that in October we ran a webinar for schools where we went through the updated children missing education guidance and set out clearly the expectations of schools that are in that guidance and how we expect them to work with you, the local authority, on the CME duties. This webinar was following the same session that we ran for local authorities back in September, which focused on the most relevant parts to local authorities. As many of you will already be aware from various pieces of correspondence, during the webinar for schools, some concerns were raised around joint working between local authorities and schools in following Regulation 9 of the School Attendance Pupil Registration Regulations. So we wanted to take the opportunity to put this webinar on today to sort of readdress and clarify some of those regulations, hopefully clarifying any confusion that there might be around the grounds for deletion. We do have a lot to get through today, and as I say, I really do want to give as much time to the Q&A section as possible. But today, so what we'll do firstly is we just want to take some time to acknowledge some of the feedback that we've had from local authorities regarding school practice with the regulations, and just to hopefully offer some reassurance around what we're doing to engage schools and work with them to ensure consistency in how the regulations are being applied. We'll then do a bit of a sort of high-level overview of the school attendance pupil registration regulations, again focusing on Regulation 9.1, so the grounds for deletion of names from the admissions register. I'm then going to hand over to Faye, who will talk us through each of the grounds for deletion. In response to some of the queries that we've had from both local authorities and schools, this will predominantly focus on grounds H and I, which require that joint agreement and working of local authorities and schools together, but we will run through them all, just hopefully that will be helpful for you. We then want to share with you some of the feedback that we've had from schools from the sessions, and then hopefully we can run through a couple of examples of best practice in relation to grounds H and I specifically. We then also want to address some of the concerns that have been raised around deletion of names from a school admissions register and potential safeguarding implications of that, and hopefully offer some reassurance in that space as well. As I say, we will then leave plenty of time for a more interactive part of the session. We'll be taking the opportunity to gather a bit of feedback from you all on the regulations in practice, especially given that it's now been a year, well, a little over a year since they were introduced. And then we will do a live Q&A and try and cover as much as possible before then running through next steps and what you can expect following the session today. Great, so Vicky, if we jump on a slide. Perfect, thank you. So as I say, before we go through the regulation and grounds for deletion, we just want to recognise some of the concerns that some local authorities have raised regarding practice amongst schools in removing children from the roll when they feel that a ground for deletion has not been met. We've heard various things from local authorities, some cases where schools are not working with or communicating with their local authorities to support pupils who have attendance challenges to return to school. Other examples of where it appears schools are using grounds H and I when the ground has not been met in full, and then also some concerns around under grounds H and I, schools not engaging with their local authority at all to seek agreement on there being no reasonable grounds to believe the pupil will attend the school again. We really hope everybody on this call received the email that was sent to both local authorities and the schools who attended the webinar yesterday. We hope that we can reassure you that we've heard these concerns, and as well as clarifying the grounds for deletion with you all today, we're also continuing to work with schools to ensure they are also clear on what it means to have met a ground for deletion in full. And that email was just the start of that as well. We're also really keen off the back of the publication of the updated children missing education guidance to ensure that schools are really clear on the expectations of them in terms of where they can reasonably support you with your CME duties as well. This includes the subject today, which is making very clear when a ground for deletion does and does not apply. As I say, we're aware it's only just been over a year since the new regulations came into place. So we're hopeful that this is quite timely to run these sessions and to clarify any confusion that might exist. Brilliant. So if we skip on again then, please, Vicky. Brilliant. So, as I said, I just wanted to provide a general overview of Regulation 9.1 of the School Attendance Pupil Registration Regulations 2024, which covers specifically the grounds for deletion of names from the admissions register. So just wanted to go over a little bit of, like, at very high level, the roles and responsibilities of schools and local authorities when it comes to following this regulation. So one of the big questions that we've had, or that has arisen a few times, is who actually makes the decision that a ground for deletion has been met. So we just want to set out, I'm sure many of you know this, the Regulation 9 states that the proprietor of a school must ensure the name of a pupil is deleted from the admissions register when a ground for deletion applies. This means the school is responsible for determining that the legal conditions are satisfied before removing a pupil. So that is for the school to determine rather than a local authority. That does, of course, not mean that there isn't a role for the local authority. While in the majority of cases, the local authority does not approve the deletion in advance. This is, of course, does not include Regulation 9.2, which covers those children that have been placed at a special school by their local authority. But the school must notify the local authority following any deletion as set out under Regulation 13. They must provide to the local authority the full details and evidence of the ground relied upon. This includes, in relation to grounds H and I, evidence of that joint agreement between the local authority and school, that there are no reasonable grounds to believe the child can reasonably be returned to the school. The school should also make a CME referral to the local authority if a child's name is deleted from the register and they're not aware that they have a school placed elsewhere or are in receipt of a suitable education otherwise. And we've also been really clear with schools that if they're unsure whether a ground applies, they should either seek their own legal advice or they should work with you or the local authority to consult with you on the evidence they feel they have before proceeding with the deletion. As I say, that's just very high level overview. I'm going to hand over to my colleague Faye now, who's going to come in and speak through the grounds for deletion in a little bit more detail.
Thanks so much, Maddie. Vicky, if you could click on to the next slide, please. Brilliant. So I'm going to take everybody through all of the grounds for deletion. As you know, there are 15 in total, so I'll move quickly through most of them, but we will spend more time on F, G, H, and I. So I can already see there's a ground G question in the chat. So I'll probably whiz through most, but then we'll spend a little bit of time on those ones. So ground A is registered at another school. This is a fairly straightforward one. When a pupil transfers, the original school must delete their name as soon as they're on the new school's register. The new school adds them on their first agreed date of attendance. So some key points to note here are, if a school attendance order still names the original school, ground A cannot be used, so ground D would apply instead. And we'll come on to that shortly. So for mobile children, for example, those of families who travel for work, the main school keeps the pupil on roll during their temporary attendance elsewhere. And for dual registered pupils, this might happen. This would be something that would have been agreed. The pupil stays on both registers. And again, that's kind of common for PRUs and hospital schools or some special schools in some circumstance. So we'll skip on to the next slide, please, Vicky. Another really straightforward one, pupil attends the nursery but does not continue onto the reception. And ground C applies when a pupil is on the roll at more than one school and the school has no reasonable grounds to believe that the pupil return. All schools involved need to agree to the deletion. And the key points to note are, again, if a school attendance order is in place, this ground cannot be used and ground D applies instead. And yeah, I think that's covered that one. So if we skip on to the next one, please. Thank you. So ground D, again, fairly straightforward, where the pupil is subject of a school attendance order that had previously named the school, but another school has now been named by the LA on that order instead. So again, very, very close working would be essential between the school and LA in these cases. Also important to note that this ground would be used over A or C, as we've previously mentioned. And then ground E is where the school attendance order might have been revoked. This applies when a pupil's had the school attendance order naming the school, but the LA has revoked it because they're satisfied the child will receive suitable education elsewhere. So again, if we skip on to the next slide, please. Ground J, we've got where a pupil is detained under a sentence of detention. This applies when a pupil is convicted and detained, but before the deletion, the school must have reasonable grounds to believe the pupil will not return after the release. Deletion would, of course, be made on a case-by-case basis, considering whether the pupil might return partway through their sentence, for example. We would expect schools to consult the youth offending team worker before using this ground. And finally, it's important to remember that pupils remain remanded in custody, awaiting trial or sentencing cannot be removed under this ground. And then ground K is a very sensitive ground. Once the school receives confirmed notification of a pupil's death, the name must be deleted from the admission register promptly to avoid unnecessary contact which may distress the family. We skip on to the next slide, please. Ground L, so again, fairly straightforward. The pupil will be over compulsory school age, will not continue into the sixth form. Again, the school must have reasonable grounds to believe the pupil will not attend again. The pupil also may not have got achieved the results to continue on to the sixth form anyway. Ground M, the pupil's a boarder at a school maintained by a local authority or academy. The boarding fees have not been paid. Again, that's a pretty straightforward one. We'll skip on to the next ground. Thank you, Vicky. Ground N, again, fairly straightforward. I feel like I'm saying this for all of these ones, and then it gets a bit more complicated. The pupil ceased to be a pupil at an independent school, maintained a special school, and O is where a pupil has been permanently excluded from the school, which of course cannot be used if the pupil, the family, are under appeal over the permanent exclusion and awaiting the outcome. So if we skip on to the next slide, please, Vicky, and I'll spend a bit longer on these grounds. So ground F is where a parent of a pupil has told the school in writing that the pupil will no longer be attending the school after a certain day and will receive education otherwise than at school. So as you all know, this is typically the ground used for those being withdrawn for elective home education. We do work really closely with the elective home education team, and we wanted to use this webinar as an opportunity to do some myth busting and allow you as local authorities to revise policies accordingly if you need to. But essentially, the regulations do state that this ground has been met when the parents gives written notice that a child will no longer attend school and will be educated otherwise than at a school. So once the date in that written notice has passed, the pupil must be deleted from the admission register. So key points to note here is that it cannot be used if a school attendance order is in place. That would, of course, require the local authority to revoke that school attendance order. And in that case, ground E would be used. No suitability check or LA consent is required at this stage, so except for those attending special schools under local authority arrangements. Children with EHCPs can still be withdrawn. The LA must review the plan and work with the family, but they can still be withdrawn for home education. Children on a child protection plan can also currently be withdrawn. Best practice is, of course, to hold a meeting first if possible, and keeping children safe in education guidance does recommend a joint meeting before withdrawal, especially for vulnerable children. But this meeting is not mandatory, and schools shouldn't be made to hold children on the admission register before this meeting takes place. New rules under the Children's Wellbeing and Schools Bill will change this ground in future, and we will of course come back to that when that is in place. But at the moment, as it stands, all of these kind of caveats apply to this ground. Obviously, after deletion, LA duties under Section 436A and all safeguarding duties apply. Schools should not be expected to make CME referrals straight after using this ground for deletion and pupils going on EHE, but of course they might wish to flag any concerns to the local authority, either via the deletion return or to the relevant teams. If you skip on to the next slide, please, Vicky. Okay, so ground G is a tricky ground. It's one that we do get a lot of correspondence on. So the school, this is our reasonable distance ground, so where the pupil no longer normally lives a reasonable distance from the school. The school must not have reasonable grounds to believe the child will attend the school again, so that's really important for the ground to be met. And the DfE does not define reasonable distance because we know it depends on individual circumstances, the family situation, geography, safe walking routes, and access to transport. We do also appreciate and understand that some local authorities might choose to join discussions about transport support, but this is optional. It should not be mandated or used to block lawful deletion under this ground. LA should also not set blanket policies on this or on kind of what is or isn't a reasonable distance, because every case is unique. So we know this still can apply even if a child hasn't moved, as circumstances, family circumstances can still change with regards to travel to the school. Again, this might be where transport support might come in from the local authority, but this will depend on each local authority. We do know and appreciate, and I've seen it in the chat already, questions on this ground, that reasonable distance not being set by the department can be frustrating for some LAs. But the principles in the ground do still stand. The decision to have a meeting with the school or family before this ground is used should of course rest with each local authority. It should be, if that is what the local authority's policy is, that should be clearly communicated to schools so they're aware of it ahead of using the ground. But it should be framed more as good practice, not as a means to block the use of the ground. So if we move on to ground H. So as Maddie said at the beginning, we did send a further clarification email yesterday, and that did cover grounds H and I. So I hope this won't be too repetitive. I'm just going to try and summarise these quickly, because I appreciate that we have communicated to you a lot on these grounds, and I don't want to kind of keep repeating. But ground H is the ground where a pupil was granted a leave of absence. They've not attended within 10 days after the agreed end of that leave of absence. The school does not have reasonable grounds to believe absence is due to sickness or an unavoidable cause. The school and local authority have worked together to locate the pupil and understand the circumstances. If they cannot find the pupil, or if they have found them, but agree that there are no reasonable grounds to believe the pupil will return, even after considering all reasonable steps to secure attendance, then the ground is met and the pupil can lawfully be deleted from the admission register. However, the ground cannot be used if health reasons explain the absence. It cannot be used if legal enforcement or support could reasonably bring the pupil back to school. And again, that agreement point, which I'm going to come back to in a minute. If we skip on to the next slide, please. Super. So this is ground I. So this is where a pupil has been continuously absent for 20 consecutive school days or more, and none of the usual authorised absence codes except G, N or O apply during that time. The school has no reasonable grounds to believe the absence is due to sickness or an unavoidable cause, and the school and local authority have worked together to try to locate the pupil and understand the circumstances. If they cannot find the pupil, or if they have found them but agree there's no reasonable grounds to believe the pupil will return, even after considering all possible support or enforcement steps, then the ground is met and the pupil's name can lawfully be deleted. However, the really, really key point, which we know we've spoken to many of you about, is the subsections in both of those grounds, IIIB, and the point around they agree. So the joint agreement that all reasonable efforts have been exhausted is needed. We did put that in the email yesterday for those who haven't seen that yet. If the school has not engaged with the local authority and agreed that there are no reasonable grounds to believe the pupil will attend again, they would need to engage first. However, it does not mean the local authority must give separate formal consent about the deletion itself once that agreement is in place that the pupil is unlikely to return, regardless of the support or enforcement put in place. And again, the ground can't be used if the child could still reasonably be supported to return, or if health reasons explain the absence. If we could pop onto the next slide, please. Super, and I'll pass it back to Maddie to cover feedback.
Brilliant. Thank you so much for that, Faye. Great. So, as I set out at the beginning, we are now going to predominantly focus on grounds H and I. I can see there's a few other questions in the chat that on some of the other grounds that we'll continue to respond to, and we can always come back to those during the Q&A session as well. But as I said, we did run a CME webinar with schools back in October now. So following this webinar, we would like to take the opportunity to share with you some of the concerns about local authority practice that were raised in relation to the grounds for deletion that Faye has just covered. Before I get into this, I do just want to really acknowledge that we know there is a lot of brilliant practice happening in this space by all of you and your teams to support children missing education. However, we do need to address some of the concerns raised, and hopefully it will clarify for you the grounds for deletion where they may be a bit confusing or feel a bit more open to interpretation, to ensure that there's improved and consistent practice in their application by both local authorities and schools. So I'm just going to run through some of the feedback that we've heard and just address where there's a few things that hopefully you can update your policies if they do seem to align to any of these things. So one of the things that we've heard about in relation to grounds H and I is local authorities unreasonably withholding agreement, that there's more that could reasonably be done to return the child to school. So here we just wanted to emphasise that agreement should not be withheld once both parties have concluded that there are no reasonable grounds to believe the child will return to school. If there aren't actionable grounds and that agreement has been met, the local authority then can't prevent deletion under the relevant ground. We also heard a small number of cases where schools felt that local authorities weren't responding promptly to requests for further local authority support to return the child to school, and particularly in relation to Section 19 referrals and awaiting confirmation as to whether that would be appropriate support to put in place for the child or not. Schools report children being on roll for prolonged periods of time when they feel they have done all that they can to return the child to school, but they're awaiting local authority action. We've also heard of some cases of blanket local policies that prevent agreement from being reached, even where potentially there may be some cases that would lead to agreement being reached. So, particularly in relation to where the whereabouts and location of the child are known. Here, we just wanted to emphasise that knowing the child's whereabouts, or specifically that they remain at the same address, is not in itself sufficient reason to believe the pupil will attend the school again or to prevent grounds H and I from being met in full. And then we've touched on this a little bit as well. There appears to be a little bit of a misconception that local authorities can prevent deletion under any of the other grounds, with the exception of Regulation 9.2 relating specifically to special schools. It is ultimately down for the school to evidence that a ground has been met in full. We've had some cases of local authorities expecting schools to keep children on roll while they assess EHE suitability, even though the ground sets out that as soon as written notice is received, the child must be removed. And then we also heard a small number of cases where under any ground, local authorities have prevented schools from removing from roll until a new school place is confirmed, when actually all but I think one of those grounds rely on a new school place being found for that child. So again, need for agreement only applies to under grounds H and I, where the location of that and circumstances of that child is known, and a school must legally delete a pupil as soon as a ground has been met in full. Even in relation to these grounds, we just wanted to mention, and I know many of you will know this already, that agree refers to the need for a shared judgment that there are no reasonable grounds to believe the pupil will return to school, not to a need for formal consent to delete once that agreement has been found. Though we do hear some concerns from local authorities, as I say, about schools not engaging on those, and we will be emphasising that point to schools as well. Brilliant. Okay, if we could skip on to the next slide, please, Vicky. So as I said, I'm going to give a really high level example for ground I, where it could potentially lead to a child being removed from role. So an example of where a ground I might apply is where a child has 20 consecutive days of unauthorised absence. The parent is not engaging with the school. The school then proceeds to put, or has already started to and continues to proceed to put support in place as set out in the working together guidance and to engage with the family, but this has been done to no avail. The school then has done everything that they can to establish that there are no reasonable grounds or further actions they could take to get the pupil to attend the school. And they then refer this case to the local authority. The local authority should then pick up this case, establish either clear actions that the school is yet to take, if they haven't done so already, or to take action themselves within their powers where it's reasonable to do so. This could be multi-agency forums, Section 19s, enforcement practice. Obviously, some or all of those may be appropriate depending on the circumstances of that individual child. If then all of the above does not succeed in returning the child, and it's agreed that doing it again would not succeed in returning the child, it would then be a reasonable next step for there to be agreement that the child will not return to the school. And this is regardless of whether the child resides in the same property or has changed location or not. The ground for deletion is then met, and following that agreement, the school must delete the child from their register. Following that deletion, the school should make a CME referral to the local authority if they're not aware that the child is registered at another school or in receipt of a suitable education otherwise, and make a deletion return to the local authority. As I say, I know that's very high level and there's lots of nuances, different cases, but that's just a bit of an example of where this might apply. If we skip on to the next slide then, please, Vicky. Brilliant. So one of the most frequently asked questions that we tend to receive is around examples of reasonable grounds to believe a pupil will not attend again. We tried to pull a bit of a list together that might give some examples to you of where you may be able to agree that there are reasonable grounds to believe a pupil will not attend again. I caveat this, of course, by saying this list is not exhaustive, and there will be some cases where it requires more than one of these to be the circumstance in order to have reasonable grounds. But some examples of this could be that all support and enforcement options have been exhausted by both the school and the local authority following the working together to improve school attendance guidance, and these have not succeeded. Cases where the family has explicitly confirmed to the school and local authority that the pupil will not return again. Where there's been prolonged absence with no indication of return, despite repeated engagement attempts. Multiple promised return dates that continue to pass without the pupil returning, and there is no unavoidable cause preventing that child from attending. And or where joint inquiries confirm there are no reasonable steps that remain to secure attendance, such as reintegration support or legal enforcement if it's appropriate. As I say, that's not an exhaustive list, that is just some examples. And again, there will be cases where more than one of these will need to apply in order to say that no further steps could be taken. Okay, if we jump onto the next slide then, please. So the other point that we thought would just be helpful to address is we've heard some local authorities express concerns about deleting pupils from school roles, even when a ground is met in full on safeguarding ground. Again, we just wanted to do a bit of myth busting in this space. Again, just to be clear, as the regulation sets out, once the ground for deletion is met, a pupil must be removed from the school register. And in the circumstances set out under grounds H and I, it's not a safeguarding measure to keep them on the school roll. I'm just going to do a quick talk through of some of the reasons why it doesn't necessarily help with safeguarding the child. So first and foremost, by keeping a child on the register when a ground for deletion has been met, it could risk creating a false sense of security and lead to further limited visibility of the child and their circumstances. This is because potentially the child appears accounted for in school records, which may actually mask the reality of their situation. It may also appear that the school is continuing to monitor the child when they're not actually doing so, which may unintentionally slow down further intervention from being put in place. This is particularly the case where the school has tried to engage with the family, but actually that's to no avail. They don't have any contact or visibility of that child. If engagement in those cases is minimal, such as them having no home visits because the family are not allowing it, the school can't reasonably assess the child's well-being. This risks creating a bit of gap where any concerns could go unnoticed. Children who are not attending and remain on registers could then become hidden from statutory oversight as a result, because their full situation is not being seen in full. There's also the risk of delayed escalation and a potential risk of breakdown in multi-agency communication where that's needed. If absence is prolonged, but the child remains on the register, escalation to the local authority could end up being delayed, and critical time for early CME intervention could also be lost. Other agencies, such as Children's Social Care, also rely and use the school data provided. Incorrect data regarding whether or not they're registered at school could lead to misaligned safeguarding plans, which hold incorrect information. If we skip on to the next slide. Thank you. There's also general safeguarding concerns around the actual suitability of education provision being provided. So keeping a child on a school register where they're actually not in receipt of any suitable education risks prolonging the educational neglect in the time that they spend out of education. So prolonged absence without removal means that that child is not accessing suitable education during this time, and that in itself is a safeguarding concern. It can lead to potential long-term harm as a result, such as poor attainment, isolation, and increased vulnerability. If a local authority is aware that a child is not receiving a suitable education, that their duty under the Education Act 1996 still applies, regardless of whether the child is on a school register or not, because the important thing is about whether or not they are receiving that suitable education. And as a result, local authorities might not be meeting their duty if they don't take further action while that child is registered. It also creates the potential for accountability issues for both local authorities and schools. So local authorities may unintentionally be underreporting the number of children missing education in the area because they are being kept on school registers. This potentially leads to a skewing of children missing education data and the severe absence data for children on roll. Local authorities also are then unable to accurately track what are effectively EHE or CME cases if some of the children are still appearing on school registers despite not actually attending or engaging with their school anymore. And if a school is keeping a child on roll when a ground for deletion has been met in full, they're also not meeting their own statutory duties under Regulation 9(1). Great, so hopefully that's helpful for you all. Policy. So